Hi everyone, you're watching the virtual Amicus and I'm Jay Lodha. So today's topic for discussion is really very interesting because it is on the law of injunctions, civil suits and under the Civil Procedure Code. Now there's a lot of confusion surrounding the same because for a normal layman, they all mean the same: ad interim orders, injunctions, types of injunctions, stay order for that matter. But it is very important for every viewer who is watching this to understand the different kinds and types of injunctions that the honorable court has to grant. Now, broadly speaking, an injunction is an equitable remedy in the form of a court order that compels a party to do a particular thing or compels it to refrain from doing certain acts. Now, there are certain ingredients that need to be satisfied when the court is fully convinced that, okay, fine, we can pass an interim order at this stage. Now, as far as the Indian legal system is concerned, broadly, they are governed by Order 39 and Section 36 and 42 of the Specific Relief Act, whereas Section 94, subclause C of the C.P.C also gives us the supplementary provision for grant of temporary injunctions. But it is also settled that there is no bar in granting injunction or supplementary orders under section 151 of the C.P.C code, which is again very, very important. Now, we decided today on the virtual amicus to take assistance from our expert on what are these different kinds of injunctions or what are these different kinds and nature of injunctions that are granted by the honorable courts. So joining us today on the virtual amicus is someone who has gained a tremendous reputation as an eloquent, as an articulate counsel. He's a distinguished advocate practicing majorly before the Honorable Rajasthan High Court at the principal seat at Jodhpur. Someone who had enrolled at bar and started practicing, way back in 2008. He specializes in original and appellate sides, practicing and specializing majorly in civil, criminal, revenue, mining, company, and arbitration matters. Today, we are joined by Mr. Muktesh Maheshwari, sir. Sir, thank you so much for doing this session on a Monday morning. It really, it's a working day, and taking out time and doing this for us on law of injunctions really means a lot to me and my team. Sir, anything that you wish to say before we start with the segment?
Good morning, Jay. Thank you. Thanks a lot for the wonderful introduction. First of all, yeah, I would like to, thank you for this invitation. I got a platform to keep forward some things which I really wanted to share. And I have been following your channel closely for quite a lot now. And really, I would say greetings, congratulations to you. You are providing a good platform. Even, in fact, what I really feel is that your platform is not only restricted to people belonging to legal fraternity, but a layman can also connect to it. And that's really something so wonderful. And it's the need of an hour. So thank you. Great work here. I really wish you all the best.
Thank you so much, sir, there for all the kind words. The objective behind the virtual amicus, the idea was to solve certain legal issues, legal complicated issues, and to do it in the simplest of the way so that it is easier for everyone to understand and comprehend. And that is what we have subscribed to. So, sir, the stage is set. The floor is all yours. Law of injunctions, over to you.
Thank you. Thank you. Okay. Injunctions. We all understand. I mean, injunction is a word we often use it in the legal fraternity. Not much common for the layman. But, I will start with a very basic thing. A layman would understand that there's a word called stay. Stay. Stay is something which is often connected to everything if it comes to a court proceeding. It's an integral part of anything. So how does this law of injunction evolved? How does it came from? I'll start from that. You see, this injunction word, it's nowhere defined in the Code of Civil Procedure. You just gave some idea about Code of Civil Procedure that how the suit for injunctions are filed and how temporary injunctions are granted. But interestingly, you will not find this word injunction defined anywhere in Code of Civil Procedure. From where did this word injunction came into existence? This is a very old concept, very old, and yet one of the most powerful tools for a civil court to protect the civil rights of an individual. You see, injunction is basically an idea, is basically a concept to order someone to do something in a particular way, in a very simple language. किसी को कुछ ऐसा कहना कि ये करो, in fact it includes कि ये मत करो, to do something in a negative way also, right? You stop doing it, don't do it, or maybe perform something in a certain particular way. So when we talk about our Indian laws, where can we find something related to injunctions? Because there have been a lot of there are a lot of civil suits throughout the country which are filed, and maximum of the litigation and civil side is generated for grant of injunction, which we call in a layman language, as I said, for the grant of stay. So where do we find this? We all know about this Specific Relief Act of 1963, right? Now, in a Specific Relief Act 1963, Chapter 3, the Part 3, it deals with the the grant of injunctions. It starts from Section 36, and as per, rather than I won't go much into the legal technicalities and I won't quote the sections. I will just try to keep my words with regards to what injunction is all about, and what type of injunctions are defined in this Specific Relief Act. See, an injunction can be in a very simplistic way. It can be of two types. One, it's in prohibitory manner. Another one is it in mandatory manner. So what do we mean by prohibitory and mandatory? This is something really important to understand, and this is something which really are the most common forms of injunctions. When we talk about prohibitory injunction, it's like prohibitory, as the word says, to restrain someone from doing something. Let's say, I'll give you an example. Let's say a person is having an immediate threat, let's say from a private individual or maybe some government body or an agency, that there would be a threat to his civil rights. Let's take a hypothetical situation that a person is having a land, a chunk of land, or maybe he's having his own house, plot, etc., anything. Some individual comes forward and say that you move out, else I'll throw you out. Or maybe it can be, it's not even about an individual, it can be also with the government. Let's say some government agency says that you are sitting here with no right and you just move out. Suppose this man wants to defend his civil right and wants a particular direction to be given to government, that I may not be thrown out because I'm sitting here with so and so legal title, which has been overlooked. Obviously, the remedy lies is to go to civil court and seek the direction against the government, or maybe the person who's trying to throw them out, throw him out of his property. So obviously he's going to seek the direction that restrain him or direct him not to commit this, dispossess me, or not to take any such action against me. So we can understand one thing: if such a direction is issued, let's say the court is satisfied and such directions are issued against a person, individual, or any agency that's prohibitory in nature, the court has directed someone not to proceed, ऐसा मत करो, या आपको डायरेक्शन दिया जाता है not to dispossess this, इसको अपनी प्रॉपर्टी से बाहर मत निकालो, because the concept of injunction, it's called mandatory injunction. As the word says, mandatory means to, I would in a very simple way, in a very simple language, I would say to act positively in a certain way. But a very important part is it has to be to act positively, right, in a certain way. I'll give you another example of how mandatory injunctions are relevant and how they are used. Let's continue with the same example what I gave you. Let's say a person, a poor fellow, is in possession of his house, property, etc. Some individual or maybe any agency throws him out. Earlier we discussed about prohibitory injunction, that there was an attempt to dispossess him. Let's say the attempt has been successful and he has been thrown out. Now what? So obviously a person would go to court और वो जाके क्या ये नहीं कहेगा कि भाई मुझे मेरी प्रॉपर्टी से on which I was legally entitled or having a valid possession, I have been thrown out illegally without adapting the due procedure of law. If at all I was to be thrown out, then the whatever has happened over my property, obviously, you see, another things do come up, like somebody has to seek for restoration of possession, someone has to seek other reliefs too. But a very, very important relief, which really has to be ancillary to everything, is the mandatory injunction. Won't he seek a relief that direct the person who has thrown me out to restore my possession, at the same time restore my status as it was existing at that point of time when I was thrown out? And if the court, apart from directing the restoration of possession, directs anything, which in legal language we sometimes call status quo ante, though it's a very different concept, but I would just, for an example, I'm saying, if the person is restored back to his possession and the court directs that whatever it was existing at that point of time may be restored back, that happens to be in mandatory form. The court has directed, do this. It happens quite a lot of times. Like Abhi, recently I was dealing in a case. Somebody tried to construct over the property which was belonging to somebody else. It was a vacant plot, and there was an attempt to construct something. On such an attempt, the person, we filed a civil suit on his behalf, and yes, there was interim injunction, which will be coming on in the later part of our discussion. But at the same time, when the suit was decreed, the court directed that whatever construction has been undertaken by this, because the court came to the conclusion कि ये जिस आदमी ने यहाँ पे कुछ construction करने की कोशिश की है on the land of plaintiff is illegal. That entire attempt is illegal. And the court directed that person कि आपने यहाँ पे जो भी construction किया है या कुछ भी attempt किया है construct करने का, please remove that with immediate effect on your own cost. So such direction, such direction of the court to act positively in a certain way is mandatory form of injunction, right? So practically and broadly, these are the two concepts of injunction which are mainly used throughout the country. In fact, everywhere, wherever there are civil rights, there has to be the concept of injunction. Sometimes we hear the word perpetual injunction. Yes. Now, perpetual, as the word says, it's something, a relief which is permanent in nature. That's where we can draw the distinction between temporary and permanent injunctions. Perpetual or permanent are one and the same thing. And as I said, the types of injunction, prohibitory, mandatory, both of them have to be by the way of perpetual injunction only, right? If there is a final decree, a final decision of the court. Now here we draw a bit distinction between the perpetual and the temporary injunctions, as these two words itself differentiate on a very broader aspect that yes, perpetual means permanent, temporary means maybe of temporary nature or for certain point of time an arrangement. I would use, and if in a very simple language I say, an arrangement for the certain period of time. I just said right now, like the injunctions in the perpetual, the permanent nature are of two types. That's of prohibitory, mandatory. But now often we come across this word of temporary injunction. What is temporary injunction again? Now this is something, the word temporary injunction, the concept of temporary injunction, it evolves as a very, very, though word temporary injunction must sound like कि ठीक है, कुछ बहुत not so relevant thing, but let me tell you, ये one of the most important part of any civil dispute होता है, और आज की डेट में it's really need of every court or need of every litigant, like somebody approaches the court. What I mean to say is, I'll try to simplify it. Like, let's say, for example, let's again come to the same example, same example which we were discussing. Let's say a person is being attempted to be dispossessed from his land, and he rushes to court and say, ki, there's been an attempt to dispossess me, uh, and he requests the court to save him. Imagine, like we all know, it's not. I mean, it's something very practical that yes, there would be issuance of summons to the other party. The other party would be directed to appear in the court, because obviously we say audi alterum partem is a very integral part of our legal system. So whatever has to be done after hearing both the sides, right? Um, what if let's say the summon goes, the other party comes, and the trial takes its own time. There has to be appreciation of witnesses, there has to be appreciation of documents, evidence, etc., everything, and then there has to be a verdict of the court relying upon the arguments and evidence of both the parties. But obviously it's going to take time, and yes, we all know that our trials do take time. Now the things have changed quite drastically, but still we are far away from that time, and we'll have a very quick and speedy disposal of any civil suit. But anyways, we all know the trials of the civil court do take time, reasonable time. Now what if somebody rushes to court and say, look, I need to be protected because that person is trying to oust me from my property. We were talking about the direction of prohibitory injunction. What if the person says, there's been an attempt to dispossess me from my property, and he's doing it right away? So immediately, please, he would request the court, please help me out. The lawyer of that person puts it before the court that, sir, look, there's been an immediate attempt of dispossessing that person. And obviously, the person who is trying to do it, or an agency which is trying to dispossess a person from his property, won't stop till the decision of the court. Obviously, they have nothing to do with that. There is no procedure to stop that person outside the court. So what if that person is ousted from his property till the time the court takes the court passes the final decree or the judgment or the verdict that, look, he is not supposed to be thrown out, and he has a title, and directs the other party to not to do it. The poor fellow might be thrown out till the time the decision takes time, the decision of the court comes out. So that's where the concept of temporary injunction comes in. Hindi mein we use it like in Rajasthan we have this system of having litigations in Hindi quite a lot of times, and in fact what I mean, at the original site we still have this use of Hindi language throughout the state, and we use it as called asthai nishedhagya in Hindi. Asthai, temporary, which means for the time being, and not something in permanent nature. So that's where this concept of temporary injunction comes in. We have Order 39 of the Code of Civil Procedure, which is specifically enacted to deal with this type of situation, to protect somebody's right till the decision of the court comes in. And the temporary injunction is basically now coming to this fact that temporary injunction, though there is a provision, Order 39, Rule 1 and 2 are the primary rules which deals with that when temporary injunction can be granted. There are certain criteria of it. And anyways, as I said, I won't be going too much into legality or technicalities of the sections or the laws. But still, like, can this temporary injunction be, again, the question arises is, like, if somebody files a suit claiming certain rights, can this concept of temporary injunction be like as ipso facto with the suit that, yes, if there is a suit for injunction, a perpetual injunction in any form, whether temporary injunction has to be granted or not, or whether it comes as a matter of right or not? So now, for that, it has always been a debate, and there has been lot of judgments by the Honorable Supreme Court, various high courts, our own Rajasthan High Court, that some you will find some set of judgments which deal with, yes, in certain type of cases it is required that the rights of the parties must be protected. And there have been certain verdicts which says that no, if the parties are having certain type of conducts, then there arises no question of granting any interim protection or by the way of temporary injunction. So our judicial system evolved with the concept of understanding this law of to grant this temporary injunction during the pendency of the civil suit. Because as I said, this is something really, really important. Whatever will happen in the civil suit would be the outcome of, will be the verdict which will be delivered after a long time. But is beach kya? Is Doran kya? That is something which really a big question mark the court has to deal with. So obviously to protect the rights of the party, because if somebody is ousted or the act which has to against which the person has come and court grants any prohibitory injunction or maybe a perpetual injunction in the form of prohibitory or mandatory, and if that act has already happened, the entire exercise would be, of no use. So this important concept of temporary injunction, we evolved with a system of three points of consideration which the courts say we need to deal with. One, prima facie case. Second, balance of convenience. And third, irreparable loss. Now, we all must have heard about these words throughout everywhere, but what exactly are these things? We'll discuss in a very brief and like prima facie case. And one of the most important concepts of granting of temporary injunction. In fact, this is the first point which is often decided. Just before I start with that, I just want to clarify one more very important aspect of grant of temporary injunction. As the word says, temporary, and I just said that there are requirement of decision on three important topics. That is the prima facie case, balance of convenience, irreparable loss. But again, a very important, a very important characteristic of decision of temporary injunction or the verdict of temporary injunction is that this is something prior to trial, prior to deliver of final verdict, right? I mean, prior to when the trial is completed, and this is so. So what we can say is it's a temporary injunction or temporary arrangement. The court would say that look, at this point of time, just do this so that I can come to a proper conclusion and there may not be complexity in the case. So a very important thing to understand is this is pre-trial or the pre-verdict, pre-final verdict of the court. And a very interesting thing, which again, joins the very reasoning of grant of temporary injunction is that court do not appreciate the evidence or the witnesses as it does during the grant of during the drawing of final conclusion of final decree or the final verdict. So that's where the concept of prima facie case comes into play. So as the word say, prima facie, Hindi में पहली नजर में या प्रथम दृष्टया जैसे हम कहते हैं, in a very शुद्ध हिंदी it says प्रथम दृष्टया, or maybe to very simple note, पहली नजर में means obviously like let's say a person claims that the property is his and somebody is trying to oust him. There must be something with him to prove. Let's say a person says that, look, I am over, in possession of this land, and such and such are my title documents, or maybe not title documents. Even my possession is legal, but I am being attempted to. I'm attempting since long to get my regularization over the land, and these are my, let's say, a very common proof of possession is often shown as like some electricity and water supply bills, which a person gets from the department. So the person produces that. Sometimes the photographs are produced to show that, look, I am in possession over this piece of land since so long. And sometimes some other, and it could be anything, like, to show that, look, I am here since long and there has been an attempt to dispossess me. I'm giving an example of possession or dispossession again and again because this is, something very easy to connect with. injunction, it's not temporary injunction. I'll give few examples of some other cases also, but just to connect with what the civil litigation goes through, I'm giving this example again and again. So a person comes up with all these title documents, and the court now, he requests that at least when till the time you decide my civil suit, deciding that whether at all I'm entitled for this relief or not, looking into these set of documents and looking into these uh, evidence what I am producing before the court, please consider that there is a prima facie case in my favor, and I hold at least such title or maybe such possession which is sufficient for the court to make out that, look, I have a prima facie case before the court. So the court, the civil courts in such a situation deals with this issue of prima facie case. And again, on the cost of repetition, I would say very important and the most important aspect of temporary injunction कि इस आदमी के पास में इतना सफिशिएंट मटेरियल है कोर्ट को बताने का that he has come to the court showing some of his possession or any legal right over that piece of land or the chunk of land for which he is claiming mandatory or prohibitory injunction. So once the court reaches that conclusion, look, there is sufficient material before me, which is enough to grant the temporary injunction. So the court decides the issue of prima facie case and notes that, yes, if the court comes to a positive conclusion, it could be either way. It's not necessary that the court always finds that. There have been a lot of instances where the court says, look, I do not find there is sufficient material with you to at all show that you had any sort of legal valid right over this piece of land or any property what you are claiming for. And the courts have refused the prima facie case. The courts have decided this point of prima facie case against the plaintiff. Court says, no, I will not. Similarly, we have this concept of balance of convenience. As the word says, the balance of convenience. So balance of convenience, in Hindi we call it suvidha ka santulan. So as the word itself says, the court has to look into the convenience. There's one more aspect to it. There's one more point to it. I'll give the idea about both of them together, like it's called irreparable loss. Irreparable loss, as the word says, shati, जिसे हिंदी में कहा जाता है, loss, like if the interim protection is not granted, whether the person would suffer such a loss, such a legal loss, which he won't be able to be compensated at any later stage of the suit. So when generally court decides these 2 points, the balance of convenience and irreparable loss, it looks into, apart from prima facie case, the prima facie case is again the most important part to be decided while granting the temporary injunction. But apart from that, these 2 points are to be considered separately and independently, where the court says that, look, if I grant the injunction, whether there would be any legal inconvenience caused to the other party. If I don't grant the injunction, whether he would suffer such a loss that, despite I make out that, yes, there is a prima facie case, and if I don't grant this, let's say, injunction, or I say that, what's the need of granting an injunction? Suppose if the decree is passed finally, he may be compensated, or if something wrong happens, that will be all fine. The old position can be reverted. So sometimes the court, so when deciding these 2 points, the court thinks over that and adjudicates. Let's say a person is trying to protect his property from being demolished, which is like a common litigation always generated against the local bodies like municipality, panchayats, or the trusts, where there has been a notice that, look, your possession over the piece of land is illegal and we are demolishing it. Suppose if the court says, we will not protect your, let's say the court, while dealing with the irreparable loss, the point of irreparable loss and the balance of convenience, many a times they come to a conclusion that, this person is already sitting here. अगर आज during the pendency of any civil suit or the civil trial, I do not protect this person, what the outcome would be in the absence of any temporary injunction or the stay. That's what we use it as a layman, like a temporary stay. The court says that I will not grant you any sort of injunction. The result obviously would be that the possession could be the construction could be demolished, the person could be ousted. Let's say a poor man loses his construction, and later on the court comes to again the conclusion that look, he had a right over it. What will happen then? Obviously, irreparable loss, the convenience, obviously lies in favor of a one who's claiming his title over the land. See, and again, just to put on a caveat that the grant of temporary injunction or decision of either of any of this point, किसी भी point का कोई भी decision is not a guarantee and not the final verdict of the court. There have been a lot of instances where the court, while deciding the issue of temporary injunction on a very strong words and coming to the conclusion that yes, this I see a prima facie case and balance of convenience lies in his favor, he will face irreparable loss. While appreciating the evidence and the witnesses, many a time the court says, no, I don't find any case in your favor, and your case is dismissed, or we don't grant you any relief. So, what we can conclude to this part is that temporary injunctions, asthai nishedagya, which is a temporary arrangement during the pendency of a civil suit, is basically based on the evidence you produce before the court prima facie. There is no appreciation of that evidence finally. A very important thing to be understood is that there is no final adjudication. It is only and only what court finds will just grasp of what seems appropriate. That look, yes, there is something made out in the favor of plaintiff or not. Similarly, again, something what is need to be understood is that this is totally pre-trial or pre-verdict of the court. Till the time the court pronounces a judgment, this is something which the court arranges to prevent the ends of justice. We sometimes use this word too. While arguing as a lawyer, we have to put it this way before the court. So, to sum up, yes, so far as the idea of temporary injunctions are concerned, it is something a very important and very integral part of our civil laws, and are really are the backbone of any litigation or the protection of legal rights of any person who has approached the civil court. I was talking about giving you some other examples too, like let's say, I have been giving this examples of possession, dispossession again and again because they are very easy to connect. But there are a lot of other suits too. It's not only limited to possession or dispossession. Let's say there is a suit of there is a civil suit with regards to a specific performance of a contract. That's what we say. For people who do not belong to legal fraternity or the legal have no legal idea, specific performance is something. Let's say somebody has agreed with an ex person that I'll sell you my property, or I'll do something in a particular way on a written piece of contract or maybe an oral, and the person refuses to perform that contract, then what? So most common type of cases we get is that a property which was promised to be sold, which was agreed to be sold to the person, and has now the person who agreed to do so is not doing the same. So therefore we file a suit for specific performance. Now imagine a situation. I am contesting a suit for performance for my legal rights, for getting the sale deed executed in my favor from that very particular person, and there is no protection granted to me during this point of time by the way of temporary injunction, which I would seek कि सर जब तक मेरा केस पेंडिंग है तब तक इस आदमी को ये तो रोका जाए कि ये किसी थर्ड पर्सन को उसको सेल ना कर दे. Because if suppose a third party right is created, what happens? what will happen to me? Suppose if the court comes to a conclusion, obviously we can say that yes, there is a enactment of Section 52 of the Transfer of Property Act, but uh, we all people belonging to legal fraternity knows that now how diluted the law is. There have been a lot of judgments by Honorable the Supreme Court, which says that even if there is a subsequent purchaser, then he gains a very important right, even while if he has purchased that property pending any litigation too, and therefore his right is also to be adjudicated whether he was a bona fide purchaser or not. So just imagine a situation where the court do not grant a temporary injunction during the pendency of that suit for specific performance, where I am claiming कि sir इसका sale तो मेरे favor में करा दी जाए because I have the legal agreement. And on the other hand, when the suit is decided, when the case concludes, I come to know that despite having that good decree in my favor, the further sale has already been made quite a long back. So in such a situation, I would always request it to the court that look, please, till the time the case is pending, direct this very person to not to create a third party right or to sell it to any third person, so that there may not be multiplicity of the litigation or any complexity which arises in the case. So that's why I was saying this temporary injunction is a very, very important aspect, and it's not confined to only grant of during the pendency of any suits for injunctions only, maybe permanent, any sort of permanent injunction. It is required in any, it could be required. It could be required in any other suit too. So therefore, this concept of temporary injunction again holds a very important value, and that's why it creates a backbone of every legal, most of the civil suits, I would say. And yeah. Now, coming to one another aspect to it, we were discussing about temporary injunctions. Jay, while we started, you talked about one concept called interim orders. Yeah. So this interim orders, what do we mean by this, and whether this interim or how does it affect the grant of injunctions at all? So I would just give you one very interesting, situation which arises quite a lot of time, and that is something which we as lawyers and the judiciary had to deal with that quite a lot of time. Let's say the example what I was giving was till the time the suit is decided, we have the concept of temporary injunctions. But what? And yes, the temporary injunction is granted to protect the rights of the parties till the time the suit is decided. A situation can also arise. I approach the court that today only something is happening at my property. Please protect. Because by the time you even send, because what happens is this temporary injunction is always instituted as a separate file in most of the civil courts, and a separate process is issued for it, that till the time the civil suit is decided, give an answer that why we should not protect the rights of the plaintiff. Now, a situation can arise. I go to court and I say, today only something is happening. By the time you'll issue the notice उसको मिलेगा, notice उस पे सर्व होके आएगा, वो जवाब देगा, उससे पहले तो वो सेल कर चुका होगा कहीं पे, या I am being ousted today only itself from my property. Please direct this person to not to do so immediately, because अगर notice गया या notice या summons उस आदमी के पास गए, उससे पहले तो the act for which I am apprehending would affect my legal rights would already have taken place, already would have happened. So what? So there comes the concept of ad interim injunction, right? So this ad interim injunction was something very, again, forms very, very important part of any civil suit. So this ad interim injunction means an ad interim arrangement, rather, I would again use the word, and that till the time my temporary injunction application is decided, looking to the facts and the evidence and the evidence which has come on record, protect my rights even till the time the temporary injunction application is decided. So sometimes the court does that. In fact, sometimes many times the court does that. that till the time till the time the further orders are passed or any decision is taken on the temporary injunction application, both the parties shall maintain maybe status quo, or maybe no further third party right would be created. So this concept of ad interim injunction, and as I said, this ad interim injunction can also be ex parte. Ex parte means not hearing the other party, because that is really required. Because by the time the court says that you come forward and to the other party that you come forward and answer our queries, answer the queries, or answer the plaint what has been filed before us, the act could have already happened. So sometimes ex parte injunction is granted if the court finds that yes, there is something really really strong which is lying in favor of there could be a case that where I have all the legal titles, everything which is clear to me, yet there's been an attempt to take over my property or move or maybe any act which it could be anything. So protect my legal rights, I present every of my title etc before the court, and court finds that yes, this person holds everything, and everything is perfect for this person at this stage, at least I find, then yes, the court do grant the ex parte, means without hearing the other party. So ad interim is again a concept where before the decision of temporary injunction application, the protection to the parties are given. So and as we found that what type of directions, what type of orders can be issued, and I just gave an example. I would just like to touch this point too. I just gave you an example of that. Sometimes the court grants the direction of status quo. This is often a very commonly used word in the legal fraternity, but not often people who are not from the legal fraternity are not often acquainted to it. Status quo, in Hindi we say yathasthiti, which means let's keep the things as it is in the way they are right now. Let's not change the status of the property or any XYZ thing for which the person is contesting the case before the court. This way, this order of status quo is sometimes it balances the convenience for both the parties. You see, the other party if says that I have a title over the property, sometimes there cannot be, there can be a lot of instances where there are frivolous suits. Somebody comes forward and say कि मेरा title है, जबकि a poor fellow who's already sitting there is the one who's the actual owner. Then what? So the court says that look, to balance the convenience, let's grant this order of status quo so that either of the parties are not affected by it, and the person who's lying at whichever place or whatever the nature of the property at this point of time is, let's not change it. So this is what the concept of status quo is, and which is mostly, I would not say always, mostly is granted by the way of ad interim or maybe interim to protect the rights of the parties till the time the suit is decided, or maybe by the way of ad interim injunction if till the time the temporary injunction application is decided. So this was the whole idea about injunctions. I would just touch very some other aspects to it too. Like we on the very starting of our discussion, we just said we came to understand that this injunction has never been defined in Code of Civil Procedure. So there is not a straitjacket formula when it must be granted and when must not be granted. Definitely, in Order 39, Rule 1 and 2, you will find that court can pass injunctions in certain things. In section in chapter in this specific relief act, you will find that yes, injunctions can be granted for certain things, etc. But at the same time, a specific relief act again deals with a very important section called section 41, which says that when an injunction can not be granted, like for example, the very first point of section 41, just to understand, is that there cannot be any restraint to a person from prosecuting from prosecuting a person or a court its judicial proceedings. uh, let's say, for example, there has been a decree of injunction or a mandatory injunction as we understood, directing someone that do this. The person for execution of his decree files the execution. Execution is again a very vast topic. Maybe we'll have a discussion some other day about it. But the execution, in very brief, is the implementation of the court's order. Let's say some authority of the court is trying to execute the, the decree of the court, and somebody tries to obstruct it, and somebody reaches to court and say that, look, the decree of court is being executed, but however my legal rights are there, this person may be restrained. So the court will refuse the injunction using the powers of section 41, that, look, these are executions of a judicial proceedings. No, there cannot be any grant of injunction on same. So similarly, there are certain points which are given in section 41. Another one very important point which is given in section 41, which I just remembered, is that when the person who's approaching the court does not have any personal interest in the matter, he can be refused with the injunction or any relief under the civil suit which he files. Now just imagine a person files, though there are exceptions to it. If in Code of Civil Procedure, many a times the representative suits are filed under Order 1, Rule 8. There are separate provisions to it, like Section 90, etc., for public nuisance and all. Leaving these exceptions apart, if, let's say, something wrong is happening to a person next to me, like somebody is trying to possess over a property of any X person, and a Y person comes to court and say, look, X person is being dispossessed from his property, and please give a protection of injunction for that very thing. The court can say, what's your right? What's your legal right over this piece of land, or maybe on the piece of property you are claiming your injunction? So you don't have any personal interest. So yes, in such a situation, using the powers of Order Section 41, the court can refuse the injunction. Another very interesting thing, which was amended later in the Specific Relief Act, and a very important section was inserted, which is something I really want to point out, is Section 20A. Now, if you read the language of Section 20A, it though deals with a very different chapter, but it says that it is a special provision with regards to relating to infrastructure projects, and it specifically bars कि अगर गवर्नमेंट का कोई इंफ्रास्ट्रक्चर प्रोजेक्ट है जिसके अंदर there would be a hurdle in implementation or working of that, the court would refuse the injunction. And this is something very, though it has been a very debatable section, but yes, it has been enacted, and there would be no injunction granted. Like, for example, I'll tell you, recently we were dealing with one of the case where a lot of, if you must have heard that in this desert side area and all, there were a lot of power projects which are coming up. So all of these people who claim that the land on which these power projects of the government are being established, they say, look, the land are ours by any XYZ reason, even if it has been acquired or maybe taken up for this very reason, or even if the land is legally yours, we are not in consonance with setup of such power project. The courts are mostly refusing those injunctions in those civil suits while relying upon this Section 20A. That this is something which is being done while for establishment of power projects, obviously because it is related to government. So the court refuses the injunction. The court says, even keeping every aspect of your legal rights and everything apart, but we are barred by the virtue of Section 20A. So therefore, to sum up very, very quickly, firstly, I would just say that injunction, to direct, it is to direct someone to do some act in a particular way. Injunctions can be which are granted are perpetual, like permanent in nature, are usually of two types. Permanent we are talking about, which permanent injunction comes with the final adjudication of the decree or the verdict passed by the court. There are certain exceptions which we might not like to go, like, there are certain places, certain things where certain cases where the court do like to pass certain injunctions which may lead to final relief, but that is not always, because otherwise the honorable Supreme Court has always said otherwise, that, or the high courts have always said the otherwise, that there cannot be a grant of any interim relief which decides the case finally or grants the final relief. So uh, the perpetual relief can be granted only after the verdict of the court is passed. I mean, obviously, it comes with a decree. It is of two types: prohibitory, majorly prohibitory, to restrain someone to commit the specific act, or mandatory, to to act positively in certain way, and if some hurdle, etc., has been already been created, to remove it, or to direct them that do certain thing like this. This can be prohibitory and mandatory. Then there is concept of interim injunctions. Interim injunctions are the interim arrangements which are given till the time the rights of the parties are adjudicated by the courts, to protect the status of the property, or maybe in a very simple word I would say, complexity se bachne ke liye, to avoid the complexity or multiplicity of the litigation. It can be a final interim relief or ad interim also, that till the time of final temporary injunction application is decided, till that point of time, with immediate effect, to protect somebody's right. So, and yes, there is some another aspect which I would like to discuss, is that with regards to what if CPC, the framers of CPC were very cautious about one thing. Suppose if there is a grant of interim protection by the court and there is a breach of it, then what? You see, there is the enactment of section order 39 rule 2a, which deals with if somebody breaches or somebody does not follow the provision, the order of, because obviously if that's a final decree, you have to file an execution. Though interim orders का भी execution होता है, लेकिन leaving that thing apart, since if there is breach of temporary injunction, we have the provision of order 39 2a, which we can evoke if there is breach or the court's order is not being followed. So and yes, section 41 and more particularly all of its point, and yes, 20a deals with when injunctions cannot be granted in a specific relief act. And that's it, Jay. I hope whatever was the little knowledge I was having with me, I tried to share that over these injunctions, and whatever came with my experience. So I try to keep it as simple as possible and without using much of the legal terminology.
Well, sir, what can I say? I mean, there are some sessions that just you don't want them to end. So this was definitely one of them. Perhaps not just technically it was one of the longest, but has to be one of the finest sessions recorded on the virtual Amicus. And I loved how patiently you dealt with such important concepts, and in a storytelling approach, you clarified, you explained them to all the viewers in the simplest possible ways, and you lived up to the objective of that are enshrined of this channel, the virtual Amicus. And to all the viewers who are watching, I'm sure this session must have immensely benefited. All your fundamentals, all your concepts must have been clear by now. In case if you still do, feel free to write to us. Our email is mentioned on the channel. We'll be more than happy to forward the same to our Amicus for today's session. So this session, sir, really means a lot. It takes a lot of courage to pick up a CPC concept and to deliver an hour talk, that roughly lasts for an hour, and to do it so brilliantly. Appreciate your patience, appreciate your time and the effort that you put into this. Any parting words before we wrap this up, sir? Anything towards the end that you wish to say?
Thank you. Thanks a lot for rather listening to me so patiently, because always I do hear that, whenever it comes to any lecture or speech on CPC, people do start yawning. I don't know what actually must have happened on your side, but I really enjoy doing it because I always enjoy delivering these any lecture on CPC or anything. So thanks a lot. Yeah, thanks a lot for this opportunity, and thank you.
It was an absolute honor recording this session, and I was totally glued from the word go. For this entire session. So, thank you so much, sir, once again for taking out time and doing this
Thank
really
you.
very
My
important
pleasure.
session on the law of injunctions under the Civil Procedure Code. You keep hearing this every now and then: stay ho gaya, stay mil gaya, stay nahi hua, status quo. But now, there are different kinds of interim orders, there are different kinds of injunctions. So, I'm sure that this must have benefited you. Ignorance of law is no excuse, so it's always better to keep yourself abreast and updated with what is happening around. And I'm sure this session will not only benefit the legal practitioners and the law students, but also the non-legal practitioners who are distinctly, or even, for that matter, remotely connected or associated with this field. So thank you so much, sir, once again. It's goodbye for now.
Thank you. Goodbye.